Such an exciting character to take on as an actor, and then like to have.
Hi friends, it's Mir from StarSpot USA. Welcome back to my channel. Justin Baldoni got some bad news today in court, but also Blake Lively got some bad news outside of court, so it's kind of a double whammy. They all can't be winners every day of the week. Let's talk about it. Justin Baldoni Wayfair, including Steve Sorrows, Jamie Heath, Melissa Nathan, and Jen Ale, were seeking an extension of time. They wanted 30 more days so they could finish Discovery, and they also seeking an extension on their leave. To amend their complaint back in February, they did a scheduling conference to set the deadlines for the various parts of this case to keep it on track to start in March. Brian Friedman, for his part, has stated he wants to get this trial as soon as possible. However, earlier this week he sought an extension of time from the judge and stated to the judge that Lively and Leslie Sloan and Reynolds were all disputing and not agreeing to an extension of time in an effort to be fair and to keep to his promise that he was going to keep this on track for a March 2026 deadline for the trial. To start, Judge Lyman did not give them an extension of time. If Wayfair wants to file a second amended complaint, and here's why he issued this order today and stated that Wayfair parties move for an extension of time for all parties to respond to the interrogatory served by their respected adversaries and move to amend their pleadings or to join other parties. The motion is denied for failure to show good cause. See Furry Puppet, Studio versus Fallout. Boy, the Wayfair parties have now been aware of what opposing parties contend are flaws in their operative complaint for several weeks, and the deadline to move to amend is not until April 18, 2025. Interesting, maybe. Not in order for them to get any kind of extension. In federal court, based on their rules of civil procedure, they have to be able to show and establish good cause, and it's their responsibility to show it. And it says good cause requires that the delay stem from any mistake excusable, neglect, or any other factor which might understandably account for failure of counsel to undertake or comply with the scheduling order, and to satisfy the good cause standard, the party must show that, despite its having exercised diligence, the applicable deadline could not have been reasonably met. So he's basically saying that them wanting to help reduce paperwork and hearings for the court by waiting until the judge rules on the motions to dismiss is not actually good cause, and it's not good because to seek extension of Discovery. Just because they asked for a lot of Discovery because they already agreed to it, and they haven't proven to the court that there was some sort of mistake, neglect, or other factor that was making it so that they couldn't comply. He's basically telling them, you agreed to this. Even though they asked for a lot, you can comply. So here's the problem for Wayfair. He also says that they've known since February that there were vulnerabilities in their amended complaint, and it's true. Judge Lehman Medea ruling back in February, and he stated that based upon what the New York Times had filed in their motion to dismiss, that their motion was likely to succeed on the litigation privileges that ARI afforded to the press in the state of New York. It is extremely hard to sue the New York Times and be successful, and it's very rare that they are ever held liable, even though they get sued a lot. They were sued in 1964, and that's kind of what's set up the stage for how they set actual malice for public figures for defamation. And since 1964, it's been really hard to sue them successfully, very hard. So high-profile people that file lawsuits against the New York Times, like Donald Trump, Sarah Palin, for instance, even though their cases they've believed were solid, they've had struggled to succeed, and people don't like to hear that. It's difficult to win against the New York Times, but it's a fact. And so he told them back in February they have litigation privilege, they have the protection of the press in the state of New York, and unless you can prove that New York law doesn't apply to them, this case is basically vulnerable to being tossed because they've pled a good motion to dismiss. So it was at that point that they knew that there was flaws in their case, and then Leslie Sloan brought up further issues in her motion to dismiss where she stated that a lot of the claims they had against her were pled on information and belief.
So our director, Reed Morano, she did
which are vulnerable to dismissal. It's the same reason why Jed Wallace's case is likely to get tossed that Blake Lively filed, because they don't have a lot of evidence. She has no evidence against Jed Wallace, and they have this big conspiracy against Leslie Sloan, but how they tie her into everything is not the most strong case in all of these cases. I'm just being honest. I know you don't like to heart that, so each one of them have filed their motions to dismiss, and each one of them, Blake Lively, Ryan Reynolds, Leslie Sloan, and the New York Times have provided them a blueprint of what they believe are missing in their complaints, and all of them have said they don't deserve a second amended complaint. Judge Lehman has already signed that he would be likely to approve leave to file an amended complaint, and so he signed that back in February, so they've known since February that they could simply clean up their complaint and then go through the process and fix things now before they get through the motions to dismiss, and then they have to start over. So I always and truthfully was shocked. They didn't just do a leave to file an amended complaint. So now the judge is telling them, I'm not going to go through the process of ruling on these motions to dismiss and then allow you more time after I rule on them to amend the complaint. Basically, he's saying, I don't want to get through this process, which, by the way, in federal court they have months to rule on these right months there. He wants to do this fast, meaning he wants to answer these motions to dismiss quickly, but under federal guidelines, he has months to rule. So no, he's saying, you need to decide by next week if you're going to amend, and quite honestly, it's going to make the process faster if they just amend now. But Justin and Wayfair wanted to know what the judge thought about the current complaint and if it would get through the process, and the judge is telling them, I'm not going to tell you. I'm not going to give you that courtesy. You need to decide before I tell you what I think. And they agreed in February that they wanted to get this done quickly, so I'm not surprised with his ruling. If anything, Judge Lehman is fair. He wouldn't allow Leslie Sloan to stay discovery, so he also shouldn't allow them to delay discovery. They all knew the deadlines, and as much as they know the deadlines, they also know the documents, and even if what they're requesting is a lot of documents, it's a part of litigation,